Start since we're 9 o'clock straight up. So good morning and welcome to everyone. It's good to be back in the building for me. My name is John Baza. I was previously the director of the Division of Oil, Gas, and Mining, and I retired from Utah state government near the end of last year. I have been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this and the following proceeding. So maybe just I'll take some personal privilege and make a few comments at this hearing, and I won't repeat them for the second matter, but life has been enjoyable for me, but I will apologize up front that I've forgotten many of the things I've learned over the years. So Mr. Begley is the Attorney General assisting me today as the hearing examiner. And so he's going to keep me on the straight and narrow. And I'll ask the other attorneys in the room to do the same. If I make a mistake or an error, just correct me and we'll move on. But thank you for allowing me this opportunity. Thank you for the board. Thank you for the division. And with those comments, I think we're prepared to proceed. I noticed that Director Thomas has walked in the room. Is there anything you want to say as introduction?
No, thank you, Director Baza, for allowing me to come and be part of these proceedings. Those the best I can. Politely observe. Thank you.
You and I both.
Right.
All right. So today is Wednesday, June 19th, 2024. This is the time and the place for the hearing examiner proceedings for docket number 2024-034, cause number 132-41. And I'll read the caption at this point. In the matter of the request for agency action of OVINTIV USA Inc. on border pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Wakefield UT 1-6 4-1-6-7-1 H-well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations, comprised of all of sections 6 and 7, Township 4 South, Range 1 West, USM, Duchesne County, Utah. We're holding this hearing in an anchored position in the Department of Natural Resources building in Salt Lake City, Utah. Before we begin, I'll ask, are there any members of the public or respondents? I don't see any in the room. Are there any online at this point? Okay, hearing none, we'll go ahead and proceed. I'll take appearances of counsel at this time. First of all, from the petitioner.
Thank you for that. Rich Mayo of Weir Laird LLC on behalf of the petitioner, OVINTIV USA.
Thank you, Mr. Mayo. And then from the Division of Oil, Gas, and Mining.
Yeah, Assistant Attorney General Andrew Haynes, representing the Division of Oil, Gas.
Thank you. I don't think we have any witnesses in the room, but you should have someone online. I'll go ahead and let you introduce them.
Thank you for that, Mr. Hearing Examiner. With us today remotely, by order of the board, entered on, I thought I knew, but by order of the board, with us hearing remotely are Peter Burns, landman with OVINTIV, and for the first time testifying before this board, Ms. Caitlin Heiken.
Okay. Thank you.
Would it be appropriate to have them sworn in at this time?
I think that's appropriate, but whatever works.
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you. Mr. Mayo, I think you are free to go ahead and with your presentation this time.
Well, I appreciate that, Mr. Boss. Thank you for that introduction. As noted, Mitch Mayo, Blair and Laird PLC, on behalf of the petitioner of OVINTIV USA Inc. With us today, sworn in as witnesses, are Mr. Peter Burns, who's appeared regularly. It's your first time. I want to remind the board that Mr. Burns has been recognized as an expert in petroleum line management on several occasions, and I'll be asking with presumed stipulation that he be recognized again as such. Because it's Ms. Hyken's first testimony, I'll be planning to qualify her as an expert in reservoir and general operations during her testimony. Okay. Quickly, I'd like to hit on a few things. The board, and by designation, the hearing examiner, has jurisdiction over this matter pursuant to Utah Code 40-6-6.5 and the implementing regulations. A copy of the request and issue in this cause was sent by certified mail to the known parties sought to be compulsory ruled, and sent by regular mail to all other production interest owners within the drilling unit. Their last known addresses of record disclosed by the relevant realty records or by OVINTIV's internal records. The request was also mailed to all relevant federal and state and tribal agencies, specifically including the BIA and BLM. In addition, notice of the filing of the REA and the hearing here today was duly published in the Uinta Basin Standard on May 29th and the Deseret News on May 31st. On June 10th, the division filed a response and a notice of non-opposition expressing no opposition to granting the request pending the presentation of evidence here today, which we believe will be sufficient to grant. I'd like to note, as the hearing examiner noted, there are no objections of record and no one here today to protest or respond to the request. Brief summary: this cause involves compulsory pooling of a roughly 1,271.77 acre drilling unit that was established for Lower Green River Wasatch Formation production and is comprised of sections 6 and 7, Township 4 South, Range 1 West. The drilling unit was established by board order in 2018 and cause number 139-150, as subsequently modified by cause 600-03, which reduced the Kyoto production settings. OVINTIV is the majority interest owner, as is shown on Exhibit 6 and as discussed in Mr. Burns' declaration on file. Pursuant to the current orders, 139-150 and 600-03 order, which have both been submitted as Exhibit 2, OVINTIV spud the Wakefield UT 1-6, 4-1-6-7-1H well, which may be referred to as the subject well, on September 9th, 2021, with the first production date of January 6th, 2022. At the time the REA was filed, there was one vertical or directional well existing, producing or capable of producing from the subject lands. That is identified on page 4 of the request. Pursuant to the 139-150 order, that well, the existing well, converted to being payable on a 1271.77 acre allocation as of February 1st, 2022. Also, I'd like to note there are no pooling orders applicable to the existing well, and so there's no recoupment to made as part of this here. Several owners of undevoted oil and gas interests in the subject unit have refused or failed to lease or otherwise participate. And those names are listed on page 2 of the request and will be modified here as discussed. There's one correction, speaking of it, to be made in this cause. And that is, after the filing of the request, Mr. Donald Smith, whose name to be approved, reached out to OVINTIV and leased his interest, as discussed in Mr. Burns' declaration, specifically paragraph 27. According to anytime you want.
You mentioned Mr. Burns' declaration. I didn't see it in the exhibits, but I have it filed after the REA.
It was filed about a week ago, and I copied John Bozza at utah.com and he kicked back. And I noted it, and last week Julianne sent me your our board secretary sent me your new email address, but I assumed you'd gotten it as part of the process. I apologize if you haven't.
I haven't seen it yet, so.
Okay. Should we take a 5-minute break?
Yeah, would you like a hard copy one or digital?
If I can find it, I'll try to pull it up.
I don't know if you, I mean, it's on the board book, so we can pull it up, but we can get you a hard copy and show it to you. It might be pretty helpful.
Well, it might be better with a hard copy. I'm not functioning very well.
Thank you very much. Is it, should we take a 5-minute?
Yeah, that'd be.
I think you have it. Not me.
Oh,
I'm just.
let's take a 5-minute break.
Perfect.
Thank you. See, that's why the old attorneys.
I apologize. I thought you got this part of the process.
Well, and I don't know. I've been trying to monitor Julianne's
And we are live.
Okay, thank you. We're now back on the record in this matter, and I have the declaration of Mr. Peter Burns that was filed with the Secretary of the Board on June 10th. That is in front of me, and I've asked Mr. Mayo if he would just kind of walk us through that during his introduction.
Yeah, I appreciate that. Thank you for the break, and I apologize again for the mistake, confusion. Hearing Examiner Bonza, what's happened in these proceedings recently is the parties have begun to file sworn declaration testimony ahead of the hearing. Through an inadvertence, one wasn't sent to you. But what you're looking at now is a declaration, sworn testimony of Mr. Peter Burns and this evening for this today. What we'll do is we'll discuss with them as we go through the declaration, but in broad strokes. We'll talk about whether they recognize it and whether they have any corrections to it. But it is a part of the record and it's sworn testimony. If you have any questions that you would like to ask, this is just a guide to help us shorten the world of journalism. So I'll move on with that explanation.
I will give the division an opportunity.
Well, after that delay, I think what kind of spurred that delay was I was saying that there's one correction in this request. One of the parties has leased since the request was filed, and that's Mr. Donald Smith. He has since been removed as voluntarily participated, or voluntarily pooled, and that's discussed in Mr. Burns' declaration of record. In addition, there are several estates to be pooled in this matter, as identified on pages 2 and 3 of the request on file. Although OVINTIV believes it has leased all of the successors of these estates, voluntarily pooled their interests, there may be additional parties unknown to OVINTIV claiming buy-through under these estates. And so for that reason, OVINTIV is pooling those estates to capture those unknown potential successors heirs. I'd like to note that pursuant to this board's order on May 21st, the notice of opportunity to participate required by state law was sent to them by publication. It means accepted. I'd also like to note that on file is a true and correct copy of this affidavit. As reflected on Exhibit 28 and as discussed again in Mr. Burns' resume, Mr. Burns' declaration, the average weighted fee landowner's royalty that's applicable to this well in this unit is 18.337342%. I'd like to reiterate, all notice was provided to production interest owners in the subject unit as outlined in Mr. Burns' declaration and as noted in the certificate of service on file on this cause. Costs, including plugging costs, are just and reasonable, and OVINTIV is of the mind that the risks incurred in drilling the subject well justify the imposition of a 300% risk compensation in this matter. With that introduction out of the way, I'd like to begin with my examination, brief as it may be, of Mr. Burns. Mr. Burns, can you hear me?
Yes, I can.
Okay, can you please state your name and business address for the record?
Yes, Peter Burns, and OVINTIV's address is 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
Okay. And what is your position with OVINTIV, and kind of talk about your responsibilities, especially as they relate to this unit?
Sure. I'm a land advisor with OVINTIV in the Rockies team with responsibility over this drilling unit, among others.
Okay. Now, Mr. Burns has been recognized as an expert in petroleum land management on several occasions. With hearing examiners and divisions presumed stipulation, I'd like to ask that he be recognized as an expert again in this matter.
Yeah, no objection.
Thank you. Mr. Burns, I just want to go through a little bit of your declaration testimony. Unfortunately, Mr. Bonza didn't have a chance to review before this, so I'm going to have the division and hearing examiner ask you questions of it if necessary. But I'd like to go through briefly with you and just have you kind of talk about it high level. Do you recognize the declaration? Have you seen the declaration that's been filed on your behalf?
Yes, I have.
Okay. And have you reviewed that declaration?
Yes, I have.
And are you familiar with all the allegations contained therein?
Yes.
Did you execute it or cause your counsel to execute it on your behalf? it's laid out here today constitute your full and complete testimony in this cause?
Yes, it does.
Okay. Are there any corrections or modifications you'd like to make before I turn time over to division?
No, not today.
Okay. Division.
Yeah, we don't have a, division doesn't have a lot of questions. I do have a question. This is probably more informational purposes for us, to do with the proposed JOA that gets sent out. I noticed in the proposed JOA, it sets out OVINTIV's interest and then usually other parties, and there'll be a percentage by those interests. Just so we kind of have an understanding, how does that work when you have additional parties who want to sign the JOA? Do you end up updating that JOA, or does it? I mean, what's the process that goes back for your final JOA on the well?
Yes, I mean, when we send that out to parties, that percentage is kind of a snapshot in time, as of, you know, that's the percentage that they own and OVINTIV owns at that time. So that will, you know, could potentially change as we go forward. We're able to pick up additional leases, or, you know, the other working interest owner picks up leases. So I guess just generally speaking, it is a kind of a snapshot in time, though.
Functionally, though, I think Mr. Haynes is kind of getting the same question I have. It's a big, complicated contract with a bunch of parties signing at different times. How do you handle the paper? Like, how do you send out a copy with other people's signatures and the old Exhibit A on it, or do you just send to each party an individualized JOA? How does that work?
Yeah, we send. OVINTIV has historically just entered into a JOA with each individual party. We found it's very difficult to get everyone to sign the same document, the same JOA. So we have a JOA with each partner in the well.
Okay.
But those have similar, if not identical terms. It's just a separate contract.
Correct.
Okay. No, that's helpful. Yeah, because I noticed in the proposed JOA that got sent out, at that point in time, OVINTIV, I believe it indicates that other interests are around 31%, but now OVINTIV owns like 90% or more in this well. Is that because you acquired more interest between then and now? How would you explain the difference in those numbers?
Yes, I mean, we've since picked up additional leases through the notice of opportunity to participate mailings, but also there is about 10% roughly non-op participants in this well, and so that percentage was also lumped into the, you know, the non-OVINTIV percentage in the Exhibit A. So yeah, I guess just high level, we were able to pick up, you know, quite a bit of interest since the JOA was first prepared.
Peter, can I follow up? Do you guys swap out acreage with other operators? Is any of it, have you acquired any other non-operators positions in the Wakefield since the original JOA, would you guess, or do you know?
There were some trades done, you know, several years ago, but nothing significant in the last, you know, year or two.
Okay.
All right. And then lastly, just again, we touched on it already, Mr. Donald Smith, he's now leased. Do you have any explanation, like how did that go about? Was that a result of the notice, or did he reach out to OVINTIV?
Yeah, that's directly related to him receiving the notice of opportunity and reaching out to us asking to lease. So he received that, did not want to participate or go, you know, be non-consent. So we were able to work out a lease form and get that completed before today's hearing. So we're removing him from the list of owners to be compulsory pooled, and he's now considered leased.
All right. Yeah, with that, the division doesn't have any other questions for Mr. Burns.
Okay, well, the division's questions kind of spurred some things on my end.
Happily.
Hopefully, and this is kind of a case of first impression for me since I haven't done this in a while. But maybe either you or Mr. Burns can answer some of these questions. On the JOA, if OVINTIV is the operator of the well or the unit, is there some master operating agreement that OVINTIV functions under just for day-to-day operations?
Good question.
No, I mean, this JOA or similar ones that we've executed with our, working interest partners, that is the contract and document that governs the day-to-day operations go forward.
If I heard you right, each individual working interest owner has their own contract. So is it up to them to enforce the conditions of their own contract?
Yes.
So I think there's a separate contract, and tell me if I'm wrong, Peter. I'm not trying to testify for you, so please stop me if I do. I think there's a misunderstanding. There's individual contracts, but whether the terms are materially different between those contracts is probably oversold. I think the truth is the negotiated terms may vary a little bit here to here, but my assumption would be an operator would be really careful about not negotiating certain provisions that were essential to kind of keeping track of what's going on for operations, and other provisions may be more amenable to negotiations. But I'm assuming that you just have a system that kind of keeps track of this party doesn't allow audits over this amount, or this party, is that fair, Peter?
Yeah, I mean, these JOAs are very standard. So if there is a slight difference between, one-to-one, our, land system will flag those. We're able to flag those so that we're aware of those, like on our, what we, kind of refer to as a monthly obligation calendar. But those are the kind of things that we'll get input that way. But for the most part, these JOAs are, they match from partner to partner.
I get that. As standard as they are, they're extremely complicated. I don't even claim to know everything and would know about JOAs, but I know that individually, if there are individual contracts, if a working interest owner is unhappy about something because their contract isn't being met or the obligation isn't being met, it's up to them to come forward and say, hey, I'm upset about something. Is that right?
Whether they have one shared contract or individual contracts, whoever's weak has the burden to use the contract to try to fulfill this. So I think that's
Okay. And then on the person who came forward afterwards and leased their land, there was a deadline on the notice of opportunity. I'm assuming he missed the deadline. So is OVINTIV basically giving him a favor by allowing him to lease at this point?
Yes.
yeah.
It wasn't, you aren't required to accept his lease offer at that point.
No, but just as a, measure of good faith, if we get a lease in prior to the hearing, we're going to be, open to accepting that.
The other question I had was on your declaration. You've categorized some of these interests that we're trying to rule today in two or three different categories. Can you run through those for me, since I'm not familiar with how these things work, what those categories are?
Since they're probably categories of my creation, I'll take a stab at it first. There's probably the groups you're thinking of, or there's
non-consenting CD parties.
That's a term we use. It's kind of a global term in the orders to everyone essentially. That includes the people that we gave. It also includes anyone who's unlocatable, who's one of the estates or successors. And so we have short sites kind of for each of the different groups. But in the end, the non-consenting compulsory pool parties, that's supposed to be the umbrella term that covers all of the parties named individually and any of the parties who were unlocatable they're named, but they receive a notice, or they're a state successor that we just talked about.
So the unlocatables in the states are just subsets.
Yes and no, because sometimes the mineral owners who are named to be pooled, we know John Baza owns a mineral interest. We have an address for him. We sent it to him, but it came back unclaimed. We know you're a person. You're unlocatable. You're not a state, but you're unlocatable to us because the address we have, the only address we have, fails. And so the unlocatables are mostly.
Address.
I can't live it down. But the unlocatables are mostly the successors of the estates, but with the exception for those folks who have addresses.
Okay, gotcha.
Okay.
That was the only question I had.
With that, Mr. Burns, anything based on those questions or your declaration you'd like to add before I let you go?
No, I think you explained that last one pretty well. So I think that's all for me, unless there are further questions.
Okay, please stick around for a minute. We're going to talk to Kate, and then there may be some follow-up at the end before we let you go for sure.
Sure.
Thank you. Ms. Heiken, can you hear me?
Yes,
And am I saying your last name anywhere close to correctly?
Heiken's correct.
Okay, good. Would you please state your name and spell your last name and state your business address for the record?
Caitlin Heiken, Heiken. OVINTIV's office is located at 4 Waterway Place, Suite 100, The Woodlands 77380.
Thank you for that. I appreciate it. Can you please tell me your job title and your responsibilities kind of generally at OVINTIV?
Yeah, I am a senior reservoir engineer for our Uinta asset. I work on the subsurface as well as the outlook of our production with our overall portfolio.
Okay. Would it be fair to say that you do most of your work nowadays in reservoir, but historically have done it shared between operations and reservoir?
Correct.
Okay. Now, I'd like to remind everyone, Ms. Heiken has not testified before, and she will be testifying today, hopefully as an expert. So it's probably appropriate to hear her briefly. Do you want me to pull up her resume to look at, or is it okay to just have her talk through?
Yeah, if you just talk through it, that's completely fine.
Ms. Heiken, could you please walk through? We're trying to qualify you as an expert in this matter today. So I just need you to talk through your education, for example. Where did you go to school and what did you study?
Absolutely. I went to Montana Tech of the University of Montana. I got a bachelor's degree in petroleum engineering and graduated in 2008.
Okay. Did you do any subsequent courses, education further, or any certifications post-graduation?
No.
Okay. And how long, tell me a little bit about your work history.
Yeah, I have worked in the industry for just about 16 years. I started my career off with Newfield on the drilling side. I worked offshore as well as on land, then took a position as a completions engineer for about 4 years, and then moved into the staff reservoir engineer role. OVINTIV then acquired Newfield. I was continuing on as a development reservoir engineer. And then in 2019, I was the drilling manager for just under 3 years, then the production manager for Uinta, and then recently, about a year or so, I've been the reservoir engineer for Uinta.
Okay. So that's a breadth of experience we're not used to here. Usually we have folks who are reservoir engineers and reservoir engineers only. It's nice to have someone with a little bit of broad operations experience here to talk to us. Newfield was your job out of school, and that is, I guess if I can be blunt, that's still OVINTIV.
Yes.
In company.
Yes.
That's great. Anything else from your resume that you would like to discuss, or you think the board needs, the hearing examiner needs to be aware of here before I have them ask any questions?
No.
Okay. Thank you for that.
Yeah, could you just briefly explain kind of what you do at OVINTIV right now, like on the engineering side in the Uinta Basin?
Absolutely. So I go through each of our developments and identify risks and strategy for full field development, essentially. So we put together subsurface reviews. We work with the reservoir or the other reservoir engineers that I have on my team, as well as operations, to identify those risks. And then we quantified the economic output for those projects.
And how long would you say you've been specifically working in the Uinta Basin?
I've worked in and out of Uinta Basin. I think the last 3 positions I've held have been directly, so that's since 2019. And then earlier in my career, when I was a completions engineer, I also worked in the Uinta Basin, and that was around 20, probably in and out of like the very end of 2017.
Thank you. No further questions from the division.
Ms. Hyken, this is Mr. Bassa.
Hello.
Have you testified in front of other jurisdictional bodies such as this one before?
I have been a part of OCC hearings. However, I have not gotten up on the stand, but I've been in the audience supplying information to the lawyer for examination. But I've never been on the stand before.
So you weren't ever qualified as an expert in any of those bodies?
No, sir.
I see you've worked in North Dakota. Have you had opportunity to deal with working interests and compulsory pooling in North Dakota at all?
I have not. I've dealt with the NDIC on the operation side, but not on that, not in that arena.
All right. Thank you. That's all I have.
Thank you.
I guess now's the appropriate time, if there's no more questions, to ask for any objections to Ms. Hyken being recognized as an expert.
No objection for the division.
I would recognize Ms. Hyken.
Okay. Ms. Hyken, I'm going to do similar to what I did with Mr. Burns. Please know there may be some questions digging into the declaration as we go. But real briefly, are you familiar with what's been filed as the declaration of Caleb Hyken in this cause?
Yes.
Have you reviewed that pleading?
Yes.
So you're familiar with all the allegations contained therein?
Yes.
Okay. Did you execute or cause your counsel to execute that declaration on your behalf?
Yes.
Okay. And are there any clarifications or corrections? I mentioned earlier that you are one of the rare operations and reservoir people that we get in here that can talk about both aspects really fluidly. Does your declaration state that accurately, or did counsel misstate that in a way that you feel you want to recognize it?
Yeah, in my declaration it says I was a reservoir engineer for 15 years, and I would say I'm a petroleum engineer for 15 years, not necessarily just exclusively reservoir.
Okay. Well, with hearing examiner and division's approval, I'll modify that declaration to change it to petroleum engineer and file that after here. Thank you for that, Ms. Hyken. Any other adjustments or modifications to your declaration that you'd like to make on the record?
No.
Okay. Does the declaration, as conformed to your testimony here today, constitute your full, complete, and accurate testimony in this case?
Yes.
Okay. Finally, I'm going to ask you one question in your expert opinion. A couple questions. In your expert opinion, do the actual costs for the Wakefield 1H well, as reflected in Exhibit 29, are they fair, reasonable, and necessarily incurred?
Yes.
And do you believe those costs were within a reasonable variance of the AFE costs?
Yes.
Do you also believe, in your expert opinion, the Wakefield well was economic to drill, as that term is used in the 139-150 order?
Yes.
Okay. Finally, maybe most importantly, do you believe, in your expert opinion, the risk discussed in Exhibit 31 and paragraph 9 of your declaration justified the imposition of a 300% risk compensation award in this cause?
Yes.
Thank you. With that, I'm going to turn you over to Mr. Haynes and Mr. Baza for any follow-up questions.
Yeah, thank you, Ms. Hyken. Just want to touch real briefly. We talk about costs. So we had the original AFE costs that went out on Exhibit 26. Seems like the grand total on those around $6.5 million. Actual costs, grand total of the well at this point in time is $9.8 million. Could you just give us a brief background on where those variances may have come from?
Absolutely. I will say 2.1 million of that is LOE, which was not included in the AFE. That is cost that we incurred after we initially drilled and completed those wells. On the AFE,
If I can start, just to interrupt, LOE, would you tell the folks what that stands for?
lease operating expense. That's essentially the expense it takes to keep the wells running once they're online.
Okay, thank you for that. Sorry to interrupt.
No problem. On the AFE versus actual cost, there's a delta about 1 million, give or take, and most of that resides in the completion side of things. Our commodity costs for the completion project itself went up, so our sand costs went up, our diesel costs went up, and our hydraulic horsepower went up to result in those increased costs.
Okay, thank you. And then lastly, Exhibit 31, we have kind of the pre-spud risks. The division noticed that there's not very many wells in this area, at least along like horizontals. You indicated that no operational challenges occurred with this drilling. Is that correct?
Yes.
Okay. I believe that's all the questions we have from the division. Thank you.
Thank you.
Ms. Hagen, just for full disclosure, I'm a petroleum engineer myself.
Awesome.
I've said in the past, the world owes a lot to engineers. I'm wanting to focus on Exhibit 29, which is actual cost to date. And I note that several of those costs fall into different categories, occurring over different periods of time. Maybe just for my own benefit and an explanation of what went into these major costs and why some occurred early on, some occurred later on. Could you just kind of walk through that exhibit for me?
Absolutely. That's a great question. So you can see on the drilling side, we incurred costs in 2019, 2020, even though the well was drilled in 2021. Those costs are going to be associated with title work, regulatory work when we're putting in our permits, the cost of those, as well as building the location. When you see the big number hit in 2021, that's the guts of the drilling operation where they drilled the well. And then because of when it was drilled, September was kind of the end of when it was drilled. There's some costs that happen a few months later that you're seeing kind of trickle into the subsequent years. Same thing with facilities. There was a pre-build and kind of getting the pad ready to go before we drilled it. So that's why you're seeing some costs in 2020 while the majority of the work was done in 2021.
On the facility side, is the production from this well commingled with other wells in a common facility?
I don't know the answer to that.
Okay, but we would have to assume that all of the costs that are shown on this sheet are specific to this well.
Correct.
Okay, either directly or allocated costs.
Yes.
All right. Thank you for that explanation.
Mr. Herring's-Taylor and division, with that, I'm done with presentation of my case and sheet. It's probably appropriate to move for admission of exhibits. I'd like to move for admission of all my exhibits, which are exhibits 1 through 33, with the caveat that I apparently, according to Board Secretary, did not actually file exhibit 33 just yet. The proofs of service. We typically wait as long as possible to file that so we have a chance for returns of service to come back to us. But somewhere this weekend, we also missed filing that. So I'd like to move for admission of exhibits 1 through 32 and alert Board Council that we may be moving for admission of exhibit 32 this week.
Would that include amendments because of the leasing of that additional party?
We typically don't amend the exhibits, but we will amend the declaration to clarify. And if you'd like us to amend it.
No, I don't think that's necessary, as long as that's understood.
So I guess I move for admission of exhibits 1 through 30.
Any objections from the division?
No objections by the division.
Then I'll go ahead and rule that those exhibits are accepted.
With that, just a quick reminder, notice was provided. There are no objections or protests here today. We believe the statutory and regulatory requirements have been met, and the requested relief is fair, reasonable, and justified. And I'd like to thank everyone here for their time and attention to this matter.
Okay. Does the division have any closing statements?
Yeah, the division, yeah, we have a statement. Division has reviewed the request for agency action that was filed by OVINTIV in this matter. We've reviewed the exhibits, and based on the testimony we've heard here today, the division is in support of this request.
Okay. Including the non-consent.
Yes.
Now, you may have closed already, Mr. Mayor. Do you have anything else?
I appreciate the division's thoughtful review of this. I have nothing else to add.
All right, the exhibits have been admitted, so having reviewed the request for agency action, all the exhibits and the evidence testimony presented today, I find that OVINTIV has provided sufficient notices of opportunity to the non-consenting CP parties, and that those owners identified in the request for agency action, except for the one exception, did not timely elect to participate in the wills and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geologic conditions present with these wells. I find it would be appropriate to impose the requested non-consent penalty. I also find that OVINTIV has met its burden to show they are entitled to forced pooling of named interest and other relief requested in the request for agency action. So at this point, I would ask Mr. Mayo to prepare a draft order for presentation to the board. I guess, how do we work the findings and conclusions at this point?
First, I'd be happy to do that. And what typically has happened in the past, we're happy to follow this again if you'd like, is I'll prepare a draft findings and conclusions in a recommended order. Those will be your findings, your conclusions, and your recommendations. So that I have essentially division counsel, Mr. Haynes and I will go back and forth till we feel like it's comfortable, and then we'll send it to you for you to modify how you see fit, or to sign, enter the findings and conclusions and present those to the board. But we should be able to get that to you, hopefully by Friday of this week, if not.
Mr. Bailey, are you part of that process?
Yes, I will be reviewing in conjunction with.
Okay.
He's your counsel, so we'll send it to Mike. Would you prefer us just to send it all the time, or get it cleaned up and then send it?
You can clean it up. Okay. Thank you.
Okay. And it's my understanding that these two matters will be first on the agenda at next week's board meeting.
It's a pretty quick 5-10 minute process, so it's kind of just give the board a chance to ask any questions they have.
Okay. All right, and you'll be present at that, of course.
Absolutely.
All right. So are there any other comments before we close this matter?
That's it.
All right. With that, we'll adjourn this proceeding and maybe take another 5-minute break before we begin the next one.
Perfect. Mr. Burns, you're welcome to log off now. Ms. Hike can stick around. We're going to be back in 5 minutes. Thank you, guys.
Thank you.
That's good.
Ready as soon as we are.
All right. Let's launch. Again, good morning to everyone. My name is John Baza. As I stated in the previous matter, I was previously Director of the Division of Oil, Gas, and Mining and retired from Utah State Government near the end of last year. I have been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this proceeding. Let me read the caption for this proceeding at this point. This is docket number 2024-035, cause number 132-42, in the matter of the request for agency action of OVINTIV USA Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners, Taylor UT 16-7 4-2-18-30-1 HX well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch formations comprised of all of sections 18, 19, and 30, Township 4 South, Range 2 West, USM, Duchesne County, Utah. We are holding this hearing with the anchor position in the Department of Natural Resources building, Salt Lake City, Utah. And as we begin, I note that there are no other respondents or members of the public in the room with us today. Are there any online? Hearing no one make an appearance, let's go ahead and begin. And I'll take appearances of counsel first for the petitioner.
Thank you, Mr. Hearing Examiner Mitch Mayo of Blair & Laird PLLC on behalf of Petitioner OVINTIV USA.
Okay, and from the Division of Oil, Gas, and Mining.
Yeah, Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Okay, and I was given prior to the start of the proceeding declarations from Ashley Ellison and declaration of Caitlin Hyken. These are filed pieces of testimony that will be discussed today, and I will be reviewing those as we go through the proceeding today. I think with that, Mr. Mayo, you are free to go ahead and proceed with your presentation.
I appreciate that, Mr. Hearing Examiner. With us today, as mentioned, are Mr. Ashley Ellison and Miss Caitlin Hyken. Can you both hear me okay?
Yes, sir.
Okay. It would probably be appropriate to have the witnesses sworn in at this time, if I could.
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you for that. Pursuant to board's order entered on May 21st this year, this matter was designated to this hearing examiner proceeding here today. With one major stipulation, and that's that it remained uncontested. I'd like to confirm on the record that that is still the case. Furthermore, pursuant to informal agreement of the relevant parties and in keeping with past practice, hearing examiners allowed for this submission and use of declaration testimony at this hearing, provided that the witnesses make themselves available here to answer any questions and confirm that testimony, and they are here for that purpose. The declaration of Ashley Ellison and the declaration of Kate Hyken were filed on June 10th, 2024. However, a substitute declaration of Ashley Ellison was filed the very next day, June 11th. We'll discuss a little bit why that was. Mr. Ellison has been recognized as an expert in petroleum land management prior causes. most recently in cause 132-38, just last month. And Ms. Hyken was recognized as an expert in the prior cause, 132-41. With presumed stipulation from division and hearing examiner, I move to admit them as experts in this cause as well.
Yeah, no objection by the division.
Very well, they are.
Thank you for that. The board and the hearing examiner, by lawful designation, has jurisdiction over this matter pursuant to Utah Code 40-6-6.5 and the implementing regulations. A copy of the request was sent by certified mail to the non-parties, sought to be moved, and a regular mail to all the production donors in the subject related. At their last address is disclosed by the applicable county records or by OVINTIV's internal records. In addition, the request is mailed to all relevant federal and tribal state agencies. The notice of the filing of the request and this hearing was also duly published in the U.S. Basin Standard on May 29th, the Deseret News on May 31st. On June 10th, the division filed a response and notice of non-opposition expressing no opposition to granting the request pending the presentation of satisfactory evidence today. I'd like to remind all there were no other objections filed, and there appears to be no one here in person or online to protest or object to this request. As a brief summary, this cause involves compulsory pooling in a drilling unit established for Lower Green River Wasatch production. And this unit is comprised, it's one of the longer lateral wells that the board has been approved recently. It's comprised of sections 18, 19, and 30 in Township 4 South, Range 2 West in Shane County. This unit is a 1,755.48 acre drilling unit. It was established by the board in cause number 130-14 back in December of 2022. OVINTIV is the majority interest owner, as shown on updated Exhibit 7 and stated in Mr. Ellis's substitute declaration. Also, pursuant to Order 130-14, which was the exhibit in his cause, Exhibit 2, OVINTIV spud the Taylor UT 16-7 4-2-18-30-1HX well on January 25th, 2023, for production date of September 19th. At the time the REA was filed, there were several existing vertical and directional wells producing or capable of producing from the subject lands, the existing wells, and those were all identified on pages 5 and 6 of the request. Pursuant to the 130-14 order that spaced this well, the existing wells converted to being payable on a drilling unit or 1755.48 acre allocation as of October 1st, 2020. There are no pooling orders applicable to the existing wells, so there is no need to waive recoupment with respect. Several owners have failed to lease or participate, and their names appear on page 2 or 3 of the request. There are, however, several modifications to make in this one. Those are outlined in Mr. Ellison's substitute declaration, and we'll discuss them. I'm going to briefly hit on those here. Kaiser Francis Oil Company was named to be pooled for imposition of the JOA. They have since signed the JOA. Phoenix Capital Group Holdings LLC was a successor to Terrell Head, who had non-consented and was being held to that non-consent. Subsequently, OVINTIV has agreed to accept Phoenix's election, such that they're being removed from this proceeding as well. And then there are a couple tranches of parties to address. One, Catherine Hickman, Dottie Smith, John Lynn Edrington, Rebecca Smith, the estate of Amelia Fawcett. They were each named in the request as parties to be pooled. However, OVINTIV was provided about a week ago with some very recently recorded documents that complete the chain, clarify succession, and make it so that these parties are now able to be removed as having already been voluntarily. The other tranche of people that I'd like to talk about are folks who have since leased. And in some matters, no one leases during the pendency. As you saw in the last matter, one person leased during the pendency. In this one, I want to say there were 10 or 12 people who reached out. Of those parties, we have several of them are moon heirs, relatives of board member Gordon Moon, who've received these notices in the past and something to respond. They have now and have leased Carolyn Moon, presumed heirs of Clive D. Moon, including Shiley Laritson, Cynthia Dahl, Jamie Smith, Keith Moon, Mark Moon, and Reed Moon, all sending leases. Gregory G. Moon, James Leroy Moon, aka James L. Moon, Joyce Moon Eugster, Burton L. Moon, Orvin Neal Moon, Robert P. Noble, and Venice E. Campbell. All of those parties at least since the filing of the request for agency action. And they are being removed from this pleading and have been discussed on the record in Mr. Ellison's declarations. In addition to those parties, there are several estates. Those have been identified on page 3 of the request. Again, although OVINTIV believes it has located and leased all of the successors of these estates, without a conclusive probate order, there's no way to be certain. So those estates are included to an abundance of caution to capture those possibly unknown heirs or successors to the estates. It should be noted that pursuant to board order issued on May 21st, the requisite notice of opportunity to participate was provided to each of these unknown in the best capacity possible via publication. No responses other than those discussed were received. As reflected on Exhibit 46, and as discussed in Mr. Ellison's substitute declaration, the average fee royalty to be applied to the subject well in this case is 16.8818%. Notice was provided to all production personas in the subject unit, and the certificate of service on file. And with that, I will begin my testimony, my examination of Mr. Ellison. That's all right.
Please proceed.
Mr. Ellison, could you please state your name and business address for the record, please?
Yes, sir. My name is Ashley Ellison. Business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas 77380.
Okay. And what is your position with OVINTIV? And tell us how it relates to this, to the basin and this unit in particular.
Sure. I'm a senior land negotiator for the Uinta Basin with responsibility for this drilling and spacing unit, amongst others.
Okay. And I'd like to just reiterate that Mr. Ellison is recognized as a petroleum land management expert of this cause. Turning to your declaration, Mr. Ellison, before we jump into what it is, let's jump into what it is first.
Sure.
The substitute declaration of Ashley Ellison. Are you familiar with this pleading that's been filed in this cause?
Yes, sir.
And did you, are you aware of all the allegations contained therein?
Yes, sir.
Are you also aware of the declaration of Ashley Ellison that was filed one day prior to that?
Yes, I am.
Okay. Are you familiar with the allegations contained in the substitute declaration of Ashley Ellison?
Yes, sir.
And did you cause your counsel or did you yourself execute the declaration?
Yes, sir.
Before I get into my final question of you, I'd like to ask about the declaration and the substitute declaration. It's fairly uncommon to swear under oath on June 10th to one state of facts, and then June 11th swear under oath to a different state of facts. Aside from going counsel under the boss, can you please explain to everyone here, kind of why there's two declarations in this cause and what happened?
Yeah, sure. There are basically this area is very cut up mineral wise, as in there's hundreds of owners in each different DSU, drilling and spacing unit. We use a broker to help us lease so many owners, and there's just a process through that. And usually there's a week or so process where our broker will be working to lease people, and then they might receive those leases, and then there's just a time frame where those leases then get to OVINTIV. So it was probably my error where I just needed to double check with our broker to make sure that there were any new leases that have come in within the last 2 weeks or so. So we did double check. Unfortunately, it was just after we had filed the initial declaration. But then once we realized that there were additional people that have leased, which is a good thing, we wanted to make sure that we updated the declaration accordingly.
Okay. So if I can restate a little bit, you
Sure.
have outside land broker group, Lone Wolf Energy, that you guys use to help you track down unleased interest or button up land side things that you guys don't have time internally to do.
Yes, that is correct.
And for these poolings, you probably lean pretty heavily on counsel and the broker to work together to kind of make sure that the hand and glove are talking to each other.
That is correct.
And fair to say that the substitute declaration was necessitated because the glove and hand did not talk before it was filed.
Yes, and we'll be doing better about double checking all of this stuff moving forward for any additional force poolings.
Okay. I appreciate that clarification. With that discussion on the record, can I ask you, is the substitute declaration, does that constitute your full, accurate, and complete testimony here today?
Yes, sir.
Okay. Is there anything you would like to clarify or change or modify here before I turn you over to Division Report Hearings?
No, sir. I think we've covered it.
Okay. Thank you. With that, I'm happy to turn to Division.
Thank you, Mr. Ellison. I just have a couple questions.
Yes, sir.
Just kind of general questions. So we removed a couple of parties, not the least parties, but a couple of the parties that are no longer going to be part of the poolings. I noticed some of those, let's see, some of those were parties that were only going to be noticed by publication. So like Dottie Smith, John Lynn Endrington, and Rebecca Smith. You said you received some updated recorded documents that clarified their interest. Was that a result of somebody coming forward? I mean, because I assume these parties didn't receive any notice. So could you just explain briefly what happened there?
Yeah, I don't know specifically. I just know a lot of this is just very, we try to find owners by talking to everybody that we talk to. So a lot of times, sometimes we think that there are 4 heirs of an estate. And then after we talk to some of those heirs, we discover that there's a 5th. So a lot of times it's like it's just a huge puzzle with multiple families that we're just trying to piece together with any additional information that we can figure out, I guess. So that's kind of why interest changes while we go, I guess.
In this instance, I was actually reached out to by counsel for the family broadly.
Okay.
Who sent a series of deeds, counsel from Oklahoma, a series of deeds and assignments related to the family. It wasn't clear whether he represented all of them, but seeing them of record against the subject lands is really all of it to me to say, okay, that makes sense. Very uncomfortable. So
yeah, so I've been now satisfied those parties don't need to be on there anymore. Okay. Just a question again. This is about 2 of the parties. This was in the request. This is Forex Holding LLC and Uinta Mineral Holdings LLC. In the RAA, it indicates that you received oral confirmation that they received their notice.
Yep.
The actual exhibits don't contain any delivery information. Could you speak to that?
Yeah, there's I don't necessarily know definitive, like I've talked to them, that company personally. They are over 2 or 3 of the entities that we're force pooling here. And we are actively trying to lease these parties.
Okay.
And we will probably work out a lease. These guys own minerals kind of throughout our position. So it's not as simple as just leasing this interest. We're working on them to lease multiple other interests. And we're putting them on here just in case something happens where that falls through. OVINTIV's wish is to lease everybody that is on this list. So we will be continually working on this interest to ensure that hopefully will happen. But I did orally speak to that company on the phone, and we talked about the Taylor unit. So I know that they have notice of this interest and these proceedings.
Okay, thank you.
Yes, sir.
We spoke a little bit about this in the last matter. You weren't a party to that, but this is to do with the JOA.
Sure.
In this instance, the proposed JOA example we have lists OVINTIV and PEC minerals as the two parties to that JOA.
Sure.
When you sent out a proposed JOA to the other parties, is that the one that goes to all parties, or are they modified for each individual party that it's sent out to?
Yeah, that's a great question. So that is simply an example of a standard JOA. That specific one went to PEC. However, when we send out additional JOAs, we would simply remove PEC's interest. They would go out into the other bucket, and then as an example, Phoenix Capital Group, they are a participating owner now, and we sent them a JOA with only their interest. So there's contracts with each individual party that go out and then return to us if they participate.
Yeah, thank you.
Yep. Good question.
And lastly, just you might already be aware of this, but the notice that did go out did say the well was at 66,000 feet. There's a typo in there. No, I don't think that's
didn't go up that deep.
I just want to point that out.
That's a good point.
I wonder if that's in the well completion records as well, or if that was just a council typo.
I just noticed that. I don't think anyone else read it.
No, that's fine. Thank you for bringing it to our attention. I do not believe we drilled the well that deep, but Kate can confirm.
That's what I thought. I just double checking because
Yes.
Sharp eyes is the division.
Thank you with that, Ms. Ellison, division.
Yes, sir.
My point of view, I don't have any real questions for Mr. Ellison, but I did want to acknowledge that yours is a complicated job, and you have my deepest respect for keeping all of these records straight. I've had experience in the Uinta Basin myself, dealing with multiple families, multiple heirs, and it's a big mess, frankly. So,
agreed.
Good job.
Thank you.
Thank you. Mr. Mayor.
If I can just, before I let Mr. Ellison go, if I can just kind of note something for the record based on one of the questions. Just to be aware, if a party does not receive a written election, we would not include it in the pool. This is a very unique situation because of the communications. So I'm glad you asked that question, but I want to make sure if they don't, oftentimes we kick pooling matters 2-3 months filing down the line because we don't have the sufficient letters. So just to be clear on the record, is that fair, Mr. Ellison?
Yes, sir.
Okay. With that, I think I'm done. You can just hang tight and listen if you would, but you're done for the time being, and we'll talk to Kate.
Yep.
Ms. Hyken, can you still hear me?
Yes, can you hear me?
I can. I'd like to remind you, you're under oath, and you are on YouTube. I don't know what the other reminder was. Ms. Hyken, can you please state your name and business address for the record?
Yes, my name is Caitlin Hyken. OVINTIV's business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
Okay, and your job title and responsibilities at OVINTIV generally, and as they relate to this Taylor unit?
Yes, I'm a senior reservoir engineer responsible for the assets in Uinta.
Okay. I'd like to remind everyone that Ms. Hyken was admitted as an expert petroleum engineer in this cause. Ms. Hyken, are you aware of? Have you seen and reviewed what's been filed as the declaration of Caitlin Hyken in this cause?
Yes.
Okay. Are you familiar with all the allegations contained therein?
Yes.
Did you execute it or cause your counsel to execute it on your behalf?
Yes.
Does the declaration represent your full, complete, and accurate testimony here today?
Yes.
And is there anything you would like to add or clarify?
The only piece is, again, this one stated that I have exclusively worked as a reservoir engineer, and I would say that's more of exclusively worked as a petroleum engineer.
Thank you for that correction. I'll make sure we submit an amended declaration. I'll send it to you for your approval before we do this. A couple final questions, expert opinion questions. Just to sum up, the actual costs of the Taylor 1H well, as reflected in Exhibit 47, do you believe those were fair, reasonable, and necessarily incurred and within reasonable variance of the AFE?
Yes.
Does that mean that, in your expert opinion, the Taylor 1HL was 1HX well was economic, as that term is used in the 130-14 order?
Yes.
Last question. Do you believe the risks identified in Exhibit 49 justify the imposition of a 300% risk compensation?
Yes.
With that, I don't have any further questions for Ms. Heiken, and I over to examination from the division. Hearing examiner.
Yeah, Ms. Heiken, just looking at, we talked about AFE and estimated costs. I noticed this well is around 13 million. Could you give us an explanation why this well was that high? Is it due with the length of the well, or was there any other risks that those costs estimated that high?
Yes, that's a great question. So this was our second extended lateral that we had drilled in Utah. It was around, we AFE'd it for around 13,300 feet. There was a contingency built into the AFE for potential issues that may arise due to that extended lateral and us not having executed a well that long before.
Thank you. And in your affidavit, you talked about drilling risks. You say other risks did result in inflationary pressures that increased drilling and completion costs. Do you have any further explanation on what those other risks were?
Yeah, again, it goes back to commodities, diesel prices, sand prices, things to that nature. Those did elevate slightly. However, the execution was done so well that you don't see a lot of it because of the contingency we built into the AFE. The team executed well, so the cost came in under.
Okay. All right. Thank you, Ms. Heiken. That's all for the division.
Thank you.
Ms. Heiken, this is Mr. Baza again. On Exhibit 47, this is one of your exhibits. As we did in the previous matter, this exhibit shows various amounts of money and occurring at different time periods. Could you just step through that again and briefly explain how all those amounts came to be?
Absolutely. This was actually pulled from our accounting system to try to get the most up-to-date cost, being that this well is relatively new. So you'll see it's by the month versus by the year in the previous one we discussed. So this is going to have a little bit of a lag time based on the fact that those are when invoices have hit, not necessarily the work was done, where previously it was kind of all in the same since it was a year. But that's why you see different costs throughout the month. We rig released the well in August, and then you can see on the drilling side that big cost hit in September. Same with completions. We completed the well in September, but you see the big costs are hitting in October. The previous costs before the actual execution of the drilling side were, again, title and permitting and building of pad and pre-spud operations.
Very well. The amounts on this well, and I think Mr. Hain pointed this out, are slightly greater than what we saw in the last case. I'm curious, because of the imposition of a non-consent penalty, do you foresee this well paying out fairly quickly, or do you have an opinion on that?
I think with the execution and the cost, this well will be economic, yes.
Okay. So there could be at some point where the non-consent penalty is no longer applied.
Absolutely. In all wells, I think the 300% is envisioned to be within the potential production.
Production life of the well.
Is that fair, Ms. Eichen? I mean, 300% is possible for the Taylor.
Yes.
Thank you very much.
If that concludes the questions, I guess I'm in a position now where it's probably appropriate to move for admission of exhibits 1 through 51, again with the caveat from the prior hearing. Exhibit 51 will be admitted after fair detail. Exhibits 1 through 50, I move for admission, including the declaration of Caitlin Heiken and the substitute declaration of Ashley Oates.
Yeah, no objection to that question.
Very well, let's go ahead and admit those.
Briefly, notice was provided, all the parties received. Clearly, the notice is effective as people have reached out at least participation whenever it comes in. No other parties received notice, have appeared or objected in any way. And we believe that all the statutory and regulatory requirements have been met for granting this request. With that, I'd just like to thank everyone for their time and attention and energy to today's hearing, and I would submit.
Mr. Haynes, does the division have a closing statement?
Yeah, once again, the division reviewed this request for agency action when it came in. We reviewed the associated exhibits. Just reviewed the declarations of Ms. Heiken and Mr. Ellison, and based on the testimony here today, the division is in support of this request.
Very well. So, Mr. Mayor, do you have anything further before I make a statement?
No, I think I'm good.
So, having reviewed the request for agency action, all exhibits, and having considered the evidence and testimony presented today, I find that OVINTIV has provided sufficient notices of opportunity to the non-consenting CP parties, and that those owners identified in the request for agency action did not timely elect to participate except for the amendments that we have already discussed, and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geological conditions present with these wells, and find that it would be appropriate to impose the requested non-consent penalty. I find that OVINTIV has met its burden of proof to show that they are entitled to forced pooling of the named interest and other relief requested in the RI request for agency action. I might also add at this point, thank you to Ms. Heiken, thank you to Mr. Ellison, and if you would pass on my thanks to Mr. Burns. Your information presented was succinct and accurate, and I appreciate the time taken to present today. So, Mr. Mayo, I'm going to ask you to prepare a proposed order for the board.
Happy to do that. What I'll do is I'll prepare proposed findings of fact conclusions and recommended order, and I'll get approval from Mr. Haynes that the division's okay with it. Once we do, send it to you and council for review and approval. Hopefully we'll get that email to you by Friday.
Okay. And as I indicated in the previous matter, this matter is to be presented to the board as one of the first 2 items at next week's board meeting. So I'll be present for that as well. So anything else before we conclude?
Thank you
With
for your
that,
time.
Thank you.
Thank you.
It's good to see you back in the building.
Well, we'll go ahead and adjourn this proceeding.
Thanks.
Thank you so much.
Right. Thank you, guys.
Thanks, guys.